Good afternoon, everyone. Thank you so much for coming. This is a dual event for us today. We have Constitution Day, which is federally mandated that we celebrate, but as a law school, it is a good thing that we have a celebration of the Constitution. In addition, later this month is Chief Justice John Marshall's, our namesake, birthday, so we combine these two events and we're able to find a fantastic speaker to come join us both at noon and for 5 o'clock. So tell your friends there's one more opportunity to hear the presentation. Our guest today is Professor Joel Paul, who is a professor at law at the University of California, Hastings in San Francisco. He teaches constitutional law, international economic law, and foreign relations law. He is also the former associate dean for global programs at that school. He has taught on the faculties at the University of California at Berkeley, Yale, Connecticut, Leiden University in the Netherlands, and American University in Washington. He also practiced law with an international firm and worked in politics. He has written his fourth book, it's right here, I'll use it as a prop, Without Precedent, Chief Justice John Marshall and His Times. We are so fortunate to have him today. Please join me in welcoming Professor Paul to John Marshall Law School. And while he's working up here, we have some really cool cookies. You can eat the cookies either now or at the end, so enjoy them.
Thank you very much, Dean, and I'm very impressed with your law school as well as your cookies. It's very classy. I also wanted to thank Sharon Cannon and Peggy Zimba for their help in setting up today's event. Happy Constitution Day. It's been 231 years since the signing of the Constitution. I'm not really sure that that's a date we should be celebrating. I think a more appropriate date to celebrate is a week from today, September 24th, when we'll celebrate John Marshall's birthday in 1755. And the reason for that is that while the Constitution has lasted a long time, and that's quite an incredible achievement, the Constitution really didn't have much meaning, much significance until John Marshall came along and really defined it for us and gave it some substance, some significance. When we ask the question, like, why is it that our Constitution outlasted all other written constitutions? I suspect part of that has to do with our culture of the rule of law, which is something that I think uniquely qualified us to have a written constitution. It's our commitment to the rule of law that I think is the secret sauce that makes America successful, both in terms of our politics, our legal system, as well as our economy. It makes it a much more attractive place for us to invest in, to grow businesses. It stabilizes people's expectations, and that's really important. So I want to talk today about the role of law and the role that John Marshall played in defending the rule of law, which I think is a particularly apt subject today because many of us are feeling that the rule of law is in some sense endangered in the present political moment. We have a president who was elected as a radical disruptor and who has fulfilled that campaign promise in a variety of ways. And the kinds of disrespect that he has shown, I think, to the judicial process, to courts in particular, and even to his own Department of Justice, is deeply troubling to those of us who believe, regardless of our political parties, regardless of how we voted, that the rule of law is essential as a pillar of our liberty. And a lot of people have compared this crisis to the Watergate crisis because we feel like we're on the precipice of a constitutional crisis in which two branches of government are likely to collide, or in which one branch of government has accumulated so much authority that it's really sort of trespassing on the prerogatives of the other branches of government. But I don't think that Watergate is a good analogy. I don't think it's a good analogy because in many ways this is a far more dangerous crisis than the Watergate crisis. Richard Nixon, for whatever his falls, was a man who respected the law, and he respected, at least he respected the Supreme Court. When the Supreme Court ruled in the Watergate tapes case, Richard Nixon complied with the court's order. Not so clear that we can rely on President Trump to do so. And the other thing that I think distinguishes this is that in Nixon's time, both houses of Congress were in the hands of the opposing party. And so there was a check on the president's authority. By contrast, today we have a Congress which is uniquely supine and it seems willing to go along with a lot of things that might otherwise object to. And the third difference, I think, which is important, is the relevance and the interference of a foreign adversary in our democratic processes. I think the better analogy to the current crisis is not Watergate, but it is the Jeffersonian crisis of 1801, which happens to tie to my book. And the Jeffersonian crisis, when Jefferson was elected president, people don't realize this, but the feeling that people had was kind of the feeling that many people had the day after Election Day 2016. That sort of feeling in your stomach, either you were elated because you had a president who was going to come in and drain the swamp, or you were terrified because you had this sort of radical disruptor coming in, a man who was elected, as was Jefferson, as a populist, a man who was elected with the support of rural Southern voters, who had the support of a foreign power. People don't realize it, but Jefferson's Republican Party, that is the Jeffersonian Republican Party, not the present Republican Party, the Jeffersonian Republican Party was formed not by Americans, it was formed by the French ambassador to the United States, Charles Edmond Genet, who went around the country, went up and down the eastern seaboard, starting Republican clubs. And it's those Republican clubs that eventually formed what became known as the Democratic Republican Party, but I'm going to refer to it as the Republican Party. So there was clear foreign interference in the election. And the other element here was that Jefferson was a radical disruptor. He was a guy who had fervently believed in the French Revolution, even after the Reign of Terror, even after his friend Lafayette was jailed, even after they cut off the head of King Louis, who had been not just a friend of Jefferson's, but also an American hero for his support during the American Revolution, the subject of my previous book. But the Jeffersonian moment coming to power caused a great deal of panic among the Federalists. John Adams' party wanted to find some way to try to hold back, to resist the encroachment of the Republicans into American politics. And they did so, of course, with the passage of the 1801 Judiciary Act, where they basically created the circuit courts for the first time, created 16 circuit courts, and appointed judges literally overnight to those courts. They also passed the D.C. Organic Act, which created the positions of 42 justices of the peace. And at the same time, they limited the size of the Supreme Court so that Jefferson wouldn't be able to appoint any additional justices to the Supreme Court. Well, the other problem that John Adams had was he had to fill the job of Chief Justice. And at that moment in time, Oliver Ellsworth had just retired from the court. Nobody really wanted the job of Chief Justice. It was a lousy job. Didn't pay very well. There were no really significant cases before the Supreme Court. The Supreme Court was not taken seriously as an institution. The Supreme Court in 1800 was so unimportant that when they built the Capitol, they forgot to build a courthouse. And when the court met for the first time in 1801 with, they had to, in Washington, D.C., they had to open up a small committee room in the basement of the Senate. And they met in this small little committee room, which they had to share with the district court and the Court of Appeals. And so the court really wasn't a co-equal branch of the government in any meaningful sense. So Adams offers the job to John Jay, who'd been the first Chief Justice, and John Jay says, I'm not interested. And he can't find anybody else to take the job, and in desperation, he turns to his Secretary of State, your namesake, John Marshall. And Marshall doesn't really want the job either. He wants to go back home to Virginia to be with his wife, Polly, who's sick and is taking, she's raising 10 children, and she's an invalid, basically, confined to an upstairs bedroom. And he wants to be back with his wife, but he reluctantly agrees to take the job because he feels that he has to resist the encroachment of the Republicans. And also because he can't stand Thomas Jefferson. And he can't stand Thomas Jefferson, not just for political reasons, because he's the leader of the Federalist Party in Virginia, but also because Thomas Jefferson is his cousin. And they can't stand each other. Thomas Jefferson's side of the family basically appropriated, I guess is a nice way to put it, the money that otherwise would have flowed to John Marshall's side of the family. And John Marshall grew up in abject poverty, while Thomas Jefferson grew up with enormous wealth and 500 slaves and one of the largest houses in Virginia. So Marshall takes over this job, and then Jefferson takes office, and the first thing the Republicans do when they take office is they initiate a series of impeachments of Federalist judges all around the country. The Republicans declare that they're going to get rid of the Federalist judges. And they impeach first Judge Pickering in New Hampshire, and then Judge Addison in Pennsylvania. And then they go after the Supreme Court, and they impeach one of Marshall's colleagues, Justice Samuel Chase, who was kind of a bear-like figure who was kind of growly and very disagreeable, and he was better known by his nickname, Samuel Old Bacon Face Chase. So everybody understands that they're coming after Marshall next. Everybody understands that because Jefferson has said that he thinks the president should have the power to hire and fire judges, that he thinks that he should be able to just disband the Supreme Court and appoint anybody he wants to the Supreme Court, and he definitely wants to get rid of his irksome cousin, John Marshall. So that's the scene, right? That's the moment at which Marbury versus Madison happens, and the Republicans in Congress, they repeal the 1801 Judiciary Act, canceling the circuit courts, firing the circuit court judges, which is, of course, of questionable constitutionality, and also increasing the size of the Supreme Court, canceling the Supreme Court's term in 1802 just for fun, because they didn't want the Supreme Court meeting at all while they were doing these various things. And, of course, one of the things that happens is when Jefferson takes office is he notices this stack of 42 commissions for the justices of the peace and says, I'm not going to deliver them. We're going to hold on to those commissions. And this one guy, William Marbury, decides he really wants his commission. Now, the thing you should understand, which most people don't understand, is that William Marbury didn't really want this commission. William Marbury wanted to embarrass Thomas Jefferson. William Marbury didn't need this job. Justice of the Peace was a lousy job. The Justices of the Peace's job was primarily to go after drunks and prostitutes. And they didn't get any pay for that either. William Marbury was the president of the largest bank in the District of Columbia. He was a wealthy man. His home, coincidentally, is now the Ukrainian embassy. So there's always a Ukrainian connection to these stories. The Ukrainian embassy in Washington, D.C., it's a beautiful brick mansion in Georgetown. And William Marbury is only out to get Thomas Jefferson. That's what he's trying to do. And his lawyer, Charles Lee, is one of the smartest men around in Virginia at the time. And so, you know the rest of the story, more or less, or at least you know the conventional telling of the story. You know that Charles Lee files for a writ of mandamus to order the delivery of this commission to to William Marbury. And he files for the writ of mandamus in John Marshall's court, in the Supreme Court. And Marshall has to decide what to do. And there's two really glaring problems here. The first problem is that James Madison, the Secretary of State at the time who replaced John Marshall, has no intention of listening to anything the Supreme Court says. James Madison had refused even to show up in court. He didn't even send an attorney to represent him in court. So he's not going to listen to the court if the court tells him to deliver the commission. And John Marshall knows that, and he knows that if they make that order and he fails to deliver the commission, well, the court's authority is going to be undermined. The other problem that John Marshall faces is, or that William Marbury faces, is that there's no evidence that he has the right to a commission. How do you go about proving that you're entitled to a commission when the physical paper is sitting on the desk of the Secretary of State and he refuses to turn it over? The Secretary of State refuses to testify. He refuses to allow anyone in his office to testify. So John Marshall's attorney goes to the Senate and asks the Senate, to turn over their records saying that William Marbury was appropriately approved and give advice and consent to the Senate. And the Senate refuses. He can't get any evidence that he's entitled to this commission, even though everybody in the country knows the story. Everybody knows that the commissions were approved and that he was entitled to it. But you can't just walk in there and say everybody knows this. Of course, the one guy who could testify is sitting in the Supreme Court. And John Marshall can't go and testify in his own court that he was the guy who not only saw the commission, but he was the guy who put his stamp on the commission and was supposed to deliver the commission to William Marbury. So the conventional story is that John Marshall's brother, James, comes into the court, and James Marshall gives an affidavit saying that he was supposed to deliver this commission, and he forgot about it, or he ran out of time, or something like that. But for whatever reason, he forgot to deliver the commission, but he knows that there was a commission that he was supposed to deliver. And that's the only shred of evidence that they can base the claim on. It turns out that didn't really happen. And I found out it didn't happen because I found a letter that John Marshall wrote to his brother saying, shortly after Jefferson took power and before William Marbury even filed this lawsuit, Marshall writes to his brother and he says, "You're never going to believe what happened. I forgot to deliver the commissions. And my secretary was really busy and he didn't have time to deliver the commissions either. What am I going to do about it?" And it turns out that John Marshall and James Marshall got together with Charles Lee and William Marbury, and they planned the whole case from beginning to end. Not only did they plan the whole case from beginning to end, but they intentionally filed the case in the wrong court. Why did they file the case in the wrong court? Because John Marshall was clever enough to know that he didn't have the authority to get James Madison to deliver the commission. So he figured, we filed the case in the wrong court. And then after we file the case in the wrong court, we issue this decision, which of course you've all read, in which the court finds, on the one hand, that James Madison, and by extension, Thomas Jefferson, have violated the law by failing to deliver the commission which William Marbury was rightfully entitled to. And on the other hand, the court says, we don't have jurisdiction to decide the case because you filed it in the wrong court. How do they know they filed it in the wrong court? Well, they say, well, Article 3 of the Constitution only gave us original jurisdiction to hear cases involving these specific matters, and it didn't give us additional jurisdiction, so we read that as prohibiting us from Congress giving us additional jurisdiction. And on the other hand, that Section 13 of the Judiciary Act of 1789 purported to give us jurisdiction over cases like writs of mandamus. Well, first of all, Article 3 doesn't explicitly prohibit Congress from giving the court additional jurisdiction. Indeed, the court later says that Article 3 allows Congress to give the court additional appellate jurisdiction, so why couldn't Congress also give you additional original jurisdiction? And secondly, Section 13 of the Judiciary Act specifically does not say that you can file for writs of mandamus in the Supreme Court. It specifically says that you can file for writs of mandamus in the district court. So Marshall intentionally had the plaintiff file in the wrong court, then intentionally misread the statute. And he did this to establish two enduring and important principles that are the pillars of the rule of law in our country. And that is, first, the one that you all know, judicial review, the power of Congress, the power of the court to set aside acts of Congress as unconstitutional. But that proposition was not a controversial proposition. That proposition most people accepted at the time. Jefferson himself did not object to the principle that Congress's laws could be set aside by the court if they were contrary to the Constitution. The really important principle there was that the executive branch officials and their actions were reviewable by the court. That's important because that's really the foundation for administrative law. It's the foundation today for holding our executive branch officials accountable to law, accountable to acts of Congress, and accountable to the Constitution. So think how desperate our situation today would be if we hadn't established that principle in Marbury versus Madison. Now, of course, as a biographer, I feel somewhat conflicted about the fact that my hero, John Marshall, your namesake, suborned perjury and probably should have recused himself from the case in the first place since he was the principal actor. But leaving that aside, he did it, I think, out of a sense of commitment to what he believed the country was and what it could become, and a commitment to the defense of the rule of law. And it was a desperate time to resist the measures that were threatening the independence of our judiciary and our Constitution, because that's what really was at stake in Marbury versus Madison. That's not the only case in which Marshall, important ways, defended the rule of law. In a case called Little versus Barrem, which some of you may have read, Marshall establishes the principle in 1804 that the president can't legalize an act. The president can't say something's legal that is not otherwise legal. And that case was important because it established the notion that individual members of our military could be held accountable for following orders of the president if those orders were not otherwise consistent with acts of Congress. Or the case of Worcester versus Georgia, which many of you may be familiar with, in which Marshall defends the right of Native American nations to their own land with undisputed possession of their own land, subject only to the exclusive right of the federal government to purchase that land. But in doing so, he limits the power of the states to exercise their sovereignty over the Indian nations. And another example of this is the Charming Betsy case, which some of you may read in your international law classes. In the Charming Betsy case, Marshall establishes for the first time in 1804 the principle that international law is part of our law and that every act of Congress must be read in light of international law, and that in the absence of Congress explicitly saying that they intend to violate international law, we have to construe acts of Congress in a way that's consistent with international law. So that case, too, limits the power of Congress to act in ways that are inconsistent with international law. In all of these ways, Marshall had an important role in the establishment of the rule of law in our country. Who was this guy? I mean, he was born dirt poor in a log cabin, a 2-room log cabin that he shared with his 14 brothers and sisters. You didn't like sharing a room with your brother or sister when you were growing up? Imagine sharing it with 14 of those folks. His family basically eked out a living on a farm in the backwoods of Virginia, what was then the western frontier. He had no real education apart from 1 year of grammar school. And he spent, and I know you'll be jealous when I tell you this, 6 weeks at law school. He went to law school primarily because he was following the love of his life, Polly Ambler, who was living in Williamsburg at the time, and so he wanted an excuse to hang out in Williamsburg, so he went to law school there. for 6 weeks, and then she moved to Richmond, and so he quit law school and went to Richmond with her. He didn't really have an education. You all have far superior educations to John Marshall. He was everywhere. He was at every moment, every important moment in American history during the early years, for 60 years, for six decades, from 1775 up to his death in 1835. He served in the military. You may not know this. He was at Valley Forge. He was the Judge Advocate General of the Army, having no legal education at that point. He was Judge Advocate of the General of the Army. He served very closely with George Washington and with Baron von Steuben, who, the great Prussian General Baron von Steuben, who was neither a baron nor a Prussian general, but that's another story. He was a complete phony, but he was a great influence on Marshall. And he became close friends with Alexander Hamilton at Valley Forge, and he went on to fight at the Battle of Norfolk, which was a hugely influential event in his life. The Battle of Norfolk was, Norfolk at the time was the largest city in the most important, largest state in the Union, and it was burned to the ground by the British, and he witnessed this, and this terrifying sight of the destruction of this great city, once great city, I think had the effect of crystallizing his sense of the fragility of society and the need for a strong military and a strong national government, because he saw the complete failure of the state system when he was living in Valley Forge and trying to fight in the military. He went to his cousin, Thomas Jefferson, who was then the governor of Virginia, and said, "You got to give us more arms, you got to give us more money." And Thomas Jefferson said, "I'm too busy planning my new capital in Richmond to bother with this whole military thing." And as a result, the British invaded Richmond and invaded Charlottesville, where Jefferson's home was, and drove him out. I mean, he literally fled in terror and was censured, or he was threatened with censure by Patrick Henry and the Virginia legislature as a result of his cowardice during the period of the attacks on Virginia by the British. Marshall saw that the state system had failed and we needed a strong national government. He was the man. He was the guy at the ratification debates in Virginia who turned the debates around. You know, the two leading people at the ratification debates for the Constitution in Virginia were James Madison and John Marshall. And James Madison was a brilliant man with a very large head and a very dour sort of expression, and he was not very good with people, and he was had a kind of squeaky voice, and he was a very awkward person, and he was a bit of a hypochondriac. He was constantly thinking he was sick. Whether he was or wasn't, I don't know. But he really couldn't have persuaded people. Marshall was a very gregarious, funny, charming guy who had a lot of energy and enthusiasm, and people loved Marshall. And so he was really the guy who would take the delegates out for drinks and persuade them and win them over. The Constitution was ratified in Virginia by 10 votes out of, I think, 300 people. So without Marshall's intervention, we wouldn't have had a Constitution. There wouldn't have been a nation. He made the nation. He made the Constitution by his role in the ratification debates. And then he gets appointed for this mission. I'm almost done. He gets appointed for this mission to go to France. And he's sent to France by John Adams. He's just this Virginia lawyer at this point. And he's sent to France to try to persuade the French government to stop interfering in American ships. And he gets to France, and the first thing that happens is he sits down with two other Americans, delegates, to meet with Monsieur Talleyrand, who's the French foreign minister. And Talleyrand says to them, "Before we start talking, I'd like you to pay me a $4 million bribe." And Marshall says, "I'm not going to pay you a $4 million bribe. Don't get ridiculous. Don't be ridiculous." Well, Talleyrand won't talk to him, and so he takes away their passports, basically puts them essentially makes them unable to leave France, And he holds them there for 9 months, during which time they're besieged with spies and people threatening them and trying to pressure them. At one point, they're threatened with jail. I mean, this is during the French Revolutionary period, right, where people get their heads chopped off. And Marshall stands up to these guys. He doesn't realize that the woman he's living with, who's his landlady, who's also possibly the illegitimate daughter of Voltaire, and who's very charming and very beautiful and very sophisticated and not at all like his wife, Polly, who is quietly seducing him, is also a spy working for Talleyrand. So there's a lot of spying and romance going on in my story. He comes back to the States as a national hero for having stood up to the French. This is known as the XYZ affair that some of you may remember from school, maybe. And he's swept into Congress. He doesn't even want to go to Congress. He goes to Congress because George Washington says to him, you've got to go to Congress. You've got to fight, for everything I stood for in Congress. He goes to Congress, and in his single term in Congress, he becomes the leader of the Federalist Party in Congress. He's the guy who delivers the eulogy of George Washington in the House of Representatives. He's the person who famously says, first in war, first in peace, first in the hearts of his countrymen. That's John Marshall. And Marshall then is plucked out of Congress by John Adams to become Secretary of State. He doesn't want to be Secretary of State either, but he figures this is a great way to get out of Congress, right? I can become Secretary of State, kind of wait till the end of the John Adams term. It was the last 9 months of the John Adams administration. And then when John Adams leaves office, I can quietly go back home to Virginia with my wife. Didn't quite work out that way because he gets to Washington, D.C., which is still under construction, and John Marshall says, my wife hates this place. It's a swamp. We're going back to live in Quincy, Massachusetts. Here are the keys. You're in charge. And he leaves. And John Marshall ran the government for 9 months, the last year of John Adams' administration. What did that mean? He literally supervised the construction of Washington, D.C. And while he was doing that as Secretary of State, the Secretary of State's job was basically running everything else in the government. There was the only thing he didn't run was the War Department. He was in charge of issuing patents and trademarks. He was in charge of running all the territories. He ran the judicial system. The Attorney General didn't investigate criminal wrongdoing. That was all overseen by John Marshall. He was also at that time threatened with war by Britain, France, Spain, and the Barbary pirates. And he very artfully navigated his way through all of these international crises. At the same time, he's building the Capitol and running the rest of the government. And when John Adams appoints him to be Chief Justice of the Supreme Court, he is simultaneously Secretary of State and Chief Justice for a period of a couple of months, which is an interesting, also probably unconstitutional function. So you have a lot to be proud of for your namesake. I think that there was no one in the founding generation, including the now famous musical Alexander Hamilton, there was no one in the founding generation who had a more enduring influence than John Marshall, and nobody who did more to hold together the fragile unity of our nation at a critical moment early in our history. So what does all of this mean today? Well, I think what this means today is that Marshall understood the fragility of our society. He knew that the rule of law and the independence of our judicial system were the linchpins of our liberty. And he managed to creatively navigate his way through all these crises by prudently choosing his battles. And also, at every moment, managing to forge a consensus on the court. That was absolutely essential to his elevating the Supreme Court up to a co-equal branch of the government, because when Marshall joined the court, before Marshall joined the court, every judge would issue his own opinions. There was no opinion of the court. Marshall said, we've got to speak with one voice. We're under attack. We have to get all of the judges to agree to one opinion, and everybody has to sign on to it. For his 34 years as Chief Justice, longer than anyone else, Marshall participated in more than 1,100 decisions. He personally wrote more than half of those decisions, and all but 35 of his decisions were unanimous. That's an amazing record. But what makes it even more amazing is every judge who was appointed to the court after John Marshall was appointed by a Republican who intentionally chose a Republican judge, who would defeat Marshall's jurisprudence. And yet, through his personality and his intellect and his willingness to compromise, he was able to forge common ground in every circumstance. That was essential to his success. Democracy, I think, requires practical statesmen and jurists who prefer compromise to chaos, and who understand that the single-minded pursuit of one's own ideology or one's own ego is a path to civil war. More than any other American, Marshall set the foundations of our Constitution, of our international law, of our legal system. And his influence continues to endure more than 2 centuries later. He had the courage of his imagination, the wisdom to seek a common ground, and the grace to forge unity. Those are the characteristics that I think we need now more than ever. Thank you.
So we'll be taking a few questions from the audience. Oh, there you go. There's your first one. Promise to give the mic back.
Your book is terrific. It's a wonderful book. I highly recommend it to everybody here.
And I just happen to have some.
And you just happen to have a couple of copies. I mentioned to the professor that I unfortunately, your book's on my Kindle. You couldn't sign it for me. But anyway, I'm going to let you tell the anecdote in there that I think law students would appreciate about finding John Marshall's law school notebooks and having the name written over and over and over again. If you could tell that story.
Yeah, right. No, so as I said, when John Marshall went to law school, he did because he wanted to be close to Polly Ambler, his love. I should maybe I wouldn't explain that. Well, I will explain that. So Marshall meets Polly Ambler when he is 26 and she's 13. And he falls in love with the 13-year-old girl, but he doesn't do anything about it. He decides he's going to wait until she becomes of age. So, but he's completely infatuated with this woman, and he writes her name over and over and over again in his notebook. So when I found his notebooks are just covered with Polly, 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 Polly. So don't feel bad if you do that with your notebooks. It's okay. It's okay. Just don't text during class.
You brought up Alexander Hamilton. What was his relationship with John Marshall? And you said you think that he had a bigger impact than anyone else. I haven't gotten to read your book yet, but I have read the book about Alexander Hamilton. And he makes a strong argument that he's perhaps the most important in creating our Constitution. What do you think John Marshall did that was more important than what Alexander Hamilton?
Good question. I was defending this position the other night. Alexander Hamilton is a great guy, one of my favorite Federalists, and also I love the Chernow book as well, and it's a great musical. But Hamilton's principal achievement, he really has 2 principal achievements. He's a brilliant man. He's probably one of the great economists in American history, and he was completely self-taught economics. But his principal achievement was that he, first of all, contributed to the Federalist Papers, which were obviously an important source of information to us today when we want to sort of understand what people thought about it. But understand that the Federalist Papers were sort of like a political advertisement. I mean, they were basically, they were intended to be propaganda to persuade people why they should support the Constitution. So very important, but we have to see them in some context. Certainly in Marshall's time, Marshall would never have thought to look at the Federalist Papers as a source of understanding of what the founders thought, even if he cared about original intent, which he didn't. But secondly, Hamilton's other great achievement, I think his greatest achievement, was the establishment of the National Bank, because he understood the importance of debt, something that I think it's fair to say our president also understands the importance of debt, but in a different way. Debt, debt is important in any economy, and I can explain why, but the National Bank helped to refinance the debts of all the states, helped to knit the country closer together. But it only was around for 20 years, and then the charter lapsed. And there's a huge fight over trying to reestablish the National Bank. Marshall was the guy who upheld the National Bank, who upheld the power of Congress to create a national bank, the second national bank. And his decisions, the principles that Marshall articulated in his opinions, that's the bedrock of our political and our legal system today. He also created the notion that Congress had the power to regulate the economy and to do pretty much anything they thought was necessary without regard for state sovereignty. The importance of that was that Marshall hoped that we could eventually eliminate slavery by establishing a strong national government and a Congress that had the authority to regulate slavery out of existence. And people understood in the context of the time, when Marshall decides Gibbons versus Ogden, for example, or McCulloch versus Maryland, people understood that those cases weren't really about railroads or about the national bank. They were about the question whether or not the national government could put slavery out of existence. So that's why I think he's more important. I don't know if he'll make a great musical. I should say, however, that my previous book, Unlikely Allies, is now a musical that I wrote and I'm very excited about. Yes?
So, could John Marshall have been confirmed today as a Supreme Court justice?
That's a really great question. No, because he had no education. He didn't have a track record. So the Republicans would be afraid that he would be, pro-choice, and the Democrats would be afraid he'd be pro-life, right? He also, he didn't have the kind of political, well, maybe he did have the kind of political connections that would make him a Chief Justice today. I don't know about that. But certainly with regard to education and with regard to, yes, with regard to education and his lack of a track record, he wouldn't be approvable today. Yes, sir.
For not having a formal education, John Marshall had this extremely keen sense of political theory. Where did he draw from in studying that political theory?
Yeah, that's a really, really good question. I'm not sure. I mean, part of it was experiential. I think in being in the military, I think that he was very close to Washington. People may not know this, but John Marshall, among his other amazing accomplishments, he wrote the first biography of a U.S. president, his biography of George Washington, which is, I think, 4 volumes, and is not worth reading. But he was greatly influenced by George Washington, and as I said, by Baron von Steuben. And he also, as a young man, he didn't have much access to books, and his dad worked for Lord Fairfax. He was a surveyor working for Lord Fairfax, who was the biggest landowner in the country. His father would bring home books from Lord Fairfax's library for his son to read, but they were, books like Blackstone's commentaries on the law. And so when he was like 15 years old, he was reading Blackstone's commentaries on the law. And I think that's where his sort of self-education came from. He was really an autodidact. You had a question also. And now yes.
Sorry about that. It was just a follow-up question on the question before. Do you think that he could be elected president today?
Well, that's an interesting question too. He was actually thought of as a presidential candidate. In fact, in 1800, you remember when Congress, had this sort of deadlock because Aaron Burr and Thomas Jefferson got the same number of electoral votes, and it wasn't clear who the Federalists were going to support, whether they were going to support Aaron Burr or Thomas Jefferson. Eventually, Hamilton intervenes and decides to throw his support over to Thomas Jefferson, which of course doesn't make Aaron Burr very happy, and we know what happened. But while that was going on, Jefferson wrote to his colleagues that he was afraid his annoying cousin, John Marshall, was going to steal the presidency, because John Marshall was an enormously popular guy at the time. And he was a popular guy with everybody. He was just a very likable person. And could he today win the presidency? You know, it's maybe, because, you know, he was a kind of Reagan-esque figure. He had the kind of enthusiasm, positive attitude, and he was very good looking. He was very tall, like Reagan, you know. So maybe he could have done that. Of course, it's hard to judge how he would have related to the current sort of technologies and ways in which we run for office, which were quite different than the way people ran for office at the time. In those days, people didn't actually seek the office. They were just sort of elected. And, you know, they would pretend, they would go through this whole pretense of pretending not to really want the job or care one way or the other. And, you know, so everything was sort of done by lieutenants. I don't know. I can't answer that. It's an interesting question, though, to ponder.
You know, I was thinking Marshall served in the executive, the legislative, the judicial,
Right.
diplomatic service within about 5 years. Maybe, I wonder if you comment, you know, today's court, nobody has been a member of the cabinet,
Right.
nobody's a member of the legislature. And I just wonder if you'd comment a little bit about the breadth of an experience like Marshall with maybe the narrowness of the experience now.
Right. That's a really good question. Of course, you know that you know, Earl Warren, many of the people who are on the court throughout our history have been people who have had that kind of experience. Robert Jackson, for example, who was the Attorney General of the United States before he became a close political lieutenant of Roosevelt's. You know, that probably, I think, gave Marshall the experience of how to compromise, of how to strike a deal, because that's what he did when he was, you know, working for the ratification of the Constitution. It was Marshall who held out the offer to the Anti-Federalists that, look, if you go along with the ratification of the Constitution, we'll write a series of 10 amendments to amend the Constitution and establish all the rights you're concerned might be threatened by a national government. So Marshall and Madison together drafted what was essentially the first draft of the Bill of Rights. He doesn't get the credit that James Madison got, but he was the guy who participated in that. Marshall understood the importance of compromise, and I fear that the people who are on the court today, both liberals and conservatives, I think are maybe too ideologically pure. And you know, we may like that when we agree with their opinions, but not so good when we have a court which is as deeply polarized and divided as it is today, and a Chief Justice who I think, whatever his good intentions might be, is unable to sort of bridge that gap, is unable to sort of forge some kind of compromise in the court. If we are facing a constitutional crisis, if we get to a point where, for example, President Trump refuses a grand jury subpoena, or President Trump refuses to leave the White House after they impeach him, or President Trump decides to fire the special counsel. If we reach a constitutional crisis and a case comes before the Supreme Court, we need the court to speak with one voice. That is essential. You know, we can't have a divided opinion like Bush versus Gore. I think it would tear the country apart. And I also think the president's inclination might be to ignore them if they decided a case against him, if the court is not speaking with one voice. So speaking with one voice is an essential attribute of the court, and I think people who are politically savvy are able to pull that together. The one member of the court who I think I have a little hope in is Elena Kagan, because I think Justice Kagan had the experience as the dean of Harvard Law School of dealing with two warring camps at Harvard Law School, and she managed somehow to make peace at Harvard, and so maybe she can make peace on the court. Yes.
Besides Madison, which is your favorite John Marshall case?
My favorite John Marshall case actually would be Johnson versus McIntosh. It's actually my favorite all-time case. It was the case. Did you guys read it in Property Law? You did read it, Johnson versus Mac? That's a case about the Indian land claims case. And in that case, and I remember sitting in my first year property law class, reading this case, and when this sort of like this moment, this kind of revelatory moment came to me, because in that case, John Marshall famously writes, John Marshall famously writes, conquest gives a title that the courts of the conqueror cannot deny. And when you know, at first it kind of bothers me because the Indians lose in that case. They seemingly lose. They actually win, but they seemingly lose in that case. But in fact, what he's sort of saying there is true, that law is not about pure justice, it's about power. Law is about power, and it's about politics, therefore. But he also manages, through his savvy, to find a way to give the Indians the ultimate, victory in the case, because he says that essentially all the claims of the Europeans, all the claims of white people, that they claimed all this territory that they couldn't in fact conquer, these are all, he calls them, an extravagant pretense. And he says that the Indians have an undisputed right to possess their own lands, and the only thing the federal government can do is the federal government has the right to buy the land, but nobody else can buy their land. No one else can take away from the Indians their rights to occupy their land.
If John Marshall was as involved in everything, why is he not as credited as, say, Madison with authoring the
Good
first
question.
10 amendments?
Here's why. I think Marbury versus Madison. I think that Marbury versus Madison eclipsed everything else that John Marshall did. Everybody, when I talk to people, and I talk to a lot of different audiences about John Marshall, they're not all as well educated as you guys are. And the only thing people know about John Marshall is, Marbury versus Madison, right? That single achievement, I think, which came in the beginning of his term on the court, eclipses everything else he did. People forget about the fact that he was a war hero, that he was a captain in the sharpshooters. He was a guy who was a very accomplished political leader. He was the head of the Federalist Party in the South. He was the guy who stood up to Jefferson and stood up to Jackson. And he was the fellow who was the hero of the XYZ affair. I mean, there's just so many other things that he did as Secretary of State and so forth that kind of get forgotten about. And one of the things I tried to do in my book is more than half the book is really about everything that happens to him before he goes on the Supreme Court, because I really think people needed a sense of the breadth of his achievements.
Any other questions?
Thank you so much for
Thank you very much.